Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, what's the role of the FTC's General Counsel? A conversation with Alden Abbott on historical and current issues. The job of the General Counsel at the Federal Trade Commission is lower profile, but nonetheless very, very important in generating the agency's mission. And that is particularly the case today as the leaders of the FTC consider expanding the FTC's administrative role and trying to do new and creative things. We're going to talk to a former general counsel of the FTC to try to understand a little better about what that role is. How does it play into the FTC's mission? And what are some of the things that we should be looking for from out of the general counsel's office at the Federal Trade Commission? But first, let's find out what's going on around the section. My co-host today is Anora Wang. Hi, Anora.
Hi, John.
All right, Anora, who's our guest today?
Our guest, Alden Abbott, is a senior research fellow at the Mercatus Center at George Mason University, where he focuses on antitrust issues. Before joining Mercatus, Alden served as the Federal Trade Commission's general counsel from 2018 to early 2021, where he represented the commission in court and provided legal advice to its representatives. Prior to working at the FTC, Alden also served in the U.S. Justice Department during the Reagan administration. Alden's other professional experiences also include his time working at Heritage Foundation and the BlackBerry. He also taught antitrust courses at Mason's and Scalia Law School from 1991 to 2018. I was one of the lucky ones who had classes from Alden, so I'm very lucky to have him here to join our conversation today.
Alden, welcome to the program.
Well, thank you, John, and thank you, Anora. Glad to be here.
Alden, as John has alluded to, the FTC's GC role could be somewhat a low-profile position, but very, very important. But I guess we can learn a little about your experiences and how you got to that position in your professional path first. Could you tell us a little bit about your experience at FTC and how did you become the General Counsel of the Federal Trade Commission?
Well, thank you for that question. It's often in this world, people who get to know you professionally, like your work, and think you're competent. I was fortunate enough to be at the FTC in the late 1970s in the Office of Policy Planning. And interestingly enough, I worked for Robert Reich, who was a Clinton administration appointee and is a professor at Berkeley now. But I got to know, and actually I'd met before coming there, Tim Muris, who had been at the FTC, and he was an attorney advisor. And later on, after working at a law firm briefly, and then in the Justice Department, and the Commerce Department, in 2000, after the 2000 election, I ran into Tim and said, "Well, I've been doing some writing and teaching, but I'd like to get back into antitrust full time." I had been an assistant general counsel and the chief counsel of the Commerce Department. I had been in the antitrust division, but I thought the FTC is an interesting place, and he was going to become chairman. And he very kindly suggested that there was an opening to head the Office of Policy and Coordination in the Bureau of Competition. And I took that opportunity and held several jobs. I was an associate director of the Bureau and actually oversaw a couple of parts of the Bureau. And then later on, I was deputy in the International Office. So I actually spent 11 years at the Commission. And I actually retired in 2012 from the career senior executive service in the federal government. I worked for a couple of years at BlackBerry as an antitrust and IP policy counsel, for 4 years at the Heritage Foundation. And then, fortunately enough, I had worked for Joe Simons. He had been my boss in the Bush administration, and he apparently liked my work, and he was kind enough to offer me the opportunity to become general counsel. And I had a great 3 years. Took a while to get there. It often takes longer to get into a job, even after it's known that you've been offered something. But I had the opportunity to work on some very interesting appellate matters and really get to know the role of the general counsel. I think one of the reasons I also was chosen for that, I had spent a few years in the 1980s, in addition to the Antitrust Division, in an office called the Office of Legal Counsel in the Justice Department, which advises the president on constitutional issues, and it sort of referees interagency statutory and legal disputes among executive branch agencies. So I had that experience, and I had gotten to do not just constitutional law, but then in the 1990s as an assistant general counsel, I managed about 40, 50 lawyers at the Commerce Department who did government contracts, administrative law of various sorts, got to know about FOIA. So I basically came back to the commission having done antitrust, but above all, I think it was helpful that I had a sort of a broad administrative law and constitutional law background.
That's very helpful. I think one takeaway, I guess, from that description of your professional past is that you have had a very good institutional knowledge and working relationship within the agency with different divisions and offices, and so that's kind of important, I think. And before you, I think other people who have occupied the GC's role or office had similar experiences. Just to name a few, Robert Petofsky, Bill Kovacic, they have all been have developing a long history with the commission before they become the general counsel. So generally, what do you think are important? I guess not qualifications, but what makes the GC role effective? How come a certain GC would be more effective in its role?
The key role a new GC must remember is he or she is representing the commission. And because you're representing the commission, you have to get to know not just you're selected by the chair, but you're voted on up or down for the appointment by all members of the commission. So even though the chair gives general policy direction, a lot of work done by GC, administrative law from FOIA issues to working with the secretary on and helping and promulgating revisions to internal rules, to dealing with labor law disputes on the staff. Those are traditional sort of administrative law issues. So it's good that you need to be able, I think, to advise the commissioner, each commissioner who may or have questions about administrative law issues, but to also remember, as I say, you are working not for any one individual commissioner but the commission as a whole. So the general counsel, because he or she represents the commission on the appellate level, the statute gives full ability to the commission to represent itself in court, doesn't have to go to the Justice Department. And if there's ever a case that goes to the Supreme Court, the commission may choose, as they did once when I was general counsel, to represent itself if the Justice Department doesn't care to support it in bringing a case or doesn't want to represent it, or if the commission just thinks it's best off representing its own interests. So it's a very important role, and you have to, I think, have the confidence of each commissioner that you are working and one for the position taken by the commission. So once the commission has issued a complaint, once there's a final commission order that has to be appealed, the general counsel's office certainly going to work on the appellate level, but it also works with the bureaus on the district court level in helping give them advice on subpoenas, on compulsory process, all sorts of issues of that sort. And why can it do that? The General Counsel's Office has lots of career experts who have done a lot of district court litigation, done a lot of appellate litigation. Our appellate lawyers usually had a lot of experience in major law firms, and they just about all had distinguished court of appeals and district court clerkships. So I have people who are, but you have to have the confidence of each commissioner. You're going to listen to what he or she says. You can speak to them individually, which I did on a regular basis. And I think that's the important thing. You have a chance to express your point of view, obviously, but that's the key.
So it's interesting because the general counsel, I think, always stays with the commission and is always the commissioner's lawyer. And where that comes up, or where I've seen it come up, is in Part 3 litigation, where once a complaint is issued to an administrative law judge, the Bureau and the Commission separate. Using a Bureau of Competition, let's say, as an example, the Bureau and the Commission would separate. The GC would stay with the Commission on that side of the wall, and the Bureau, at least until the administrative trial is done and the appeal is heard, stays on the other side of the wall. Do I have that right?
That is correct. I mean, there can be special situations where there's a lawyer who would be detailed from General Counsel's office on the other side of the wall, but then he or she would have to stay on that side through the entire proceeding. But yeah, that's correct. Also, the General Counsel's office has a staff headed by Bill Cohen that helps draft commission opinions. So it's very important that they be protected. They work with the commission as a whole, but if I may say so, they provide tremendous quality control and support. And I think the commissioners have come to rely on the quality of the draft opinions that OGC often provides.
And I think there are other interesting roles. I mean, FOIA is an important function of the agency. I think that's often overlooked, but it's something the agency has to take very seriously. You talked about some of the internal employment issues that the GC has to stay on top of, some of the subpoena enforcement. But one of the things that I think is going to be really critical is the GC's role in ensuring that the commission stays on track, put it that way, as it thinks about administrative actions. Alden, could you talk to that issue a little bit? What are some of the traps, and what role does the GC play there?
Well, the GC plays a particularly important role, since shortly after I left, Acting Chair Slaughter decided to create a unit dealing with rulemaking. Now, General Counsel's office has expertise on rulemaking because it works with the bureaus on revising the rules. But and because of its role in defending the commission rules that might be appealed. But this office, as I understand it, is going to be working on developing rules, and it's expected, as I think a lot of people know, a lot of notices of proposed rulemaking, not just in the consumer protection side, but on the competition side, may be forthcoming. So it will be and there are lots of potential issues that can arise, both about creating a basis for a record, that could be upheld, particularly if you're not doing the so-called Magnuson-Moss rulemaking, but the competition rulemaking, which is more Administrative Procedure Act rulemaking. So I think that it's important for the Commission to realize issues that might arise out of the Administrative Procedure Act. You want to make sure that nothing that is done could lead to, for example, charges that action is arbitrary or capricious, and you need to develop a record. And we'll see, but I think it's going to be a very important role for the rulemaking unit.
Right.
Yeah, and it's interesting, Alden, because just by analogy, when I've been involved in trials, we've often had an appellate lawyer. I'm not an appellate lawyer, but we've often had an appellate lawyer along with us to spot the appellate issues and make sure that potential appellate issues are preserved for the record, I imagine the GC is playing sort of a similar role as in the administrative. They're not really looking for issues for appeal, but looking to head off issues for appeal.
Yes, and I think it's in a good position to do that. We have about 8 or 10 lawyers who do appellate work, headed by Joel Marcus, Deputy General Counsel. They're all outstanding appellate lawyers, top of their law school classes, top clerkships, outstanding men and women, and they can advise, and indeed do advise. I think it'll be very important for them to advise the rulemaking unit on possible pitfalls that might arise if the rule is not promulgated in the right way.
I think that's really important. I think on the FTC's website, the FTC's GC office is described as the Commission's chief legal officer and advisor. So we have seen, as already illustrated in several pieces of our discussions, that how the GC are going to represent the Commission in court when necessary. So could you give us an example, or I guess flashback to some fond memories while you were at the FTC as GC? So how would a GC be involved in the FTC's cases in court?
Well, as I said, at the district court, as I think a lot of listeners know, if there's a preliminary injunction matter in an antitrust case, the Bureau of Competition team is in court, although it may get some advice behind the scene by GC. But when there are cases of final orders or appeals of final commission orders, that's most likely when a commission is in court, or when there are appeals or questions about the constitutionality of commission actions. I think most famously, fortunately, the commission lost it, but the AMG case, AMG v. FTC, the question there was, does the FTC have authority to get monetary relief for consumers under Section 13B of the FTC Act, the injunctive provision? And when I was at the FTC in a number of matters, and over years, and I think 8 separate matters about, our lawyers had argued successfully that indeed there is power to get this relief. The Seventh Circuit held unexpectedly a split decision. No, it didn't have that authority, and then it got teed up, went to the Supreme Court, and the Justice Department chose not to. I don't think wanted to represent us, but in any event, it could have. We could have asked them, but after we lost at the Court of Appeals level, the Chairman Simons determined this was very important. We should request certiorari. We got it, and we appeared in federal court, and we had Joel Marcus argue it. It was a time when, and although we lost, I think the arguments we made were some arguments that had been successful in lower courts. So there are lots of matters. We also do amicus cases. Apple v. Pepper, where we joined with Justice Department in helping write an amicus case. Eventually, the Supreme Court looked at an issue of Illinois BRIC and its direct, indirect purchaser issue. We were involved in that. We then did joint briefs in cases like Intellectual Ventures v. Capital One, dealing with North Pennington before the Federal Circuit. We had a number of cases, 1-800-CONTACTS. Regrettably, we lost in the Court of Appeals, but that was a final commission order regarding trademarks and an agreement a company had over use of its trademarks online, 1-800-CONTACTS. I was recused in the Qualcomm case, but the General Counsel's office was responsible for that. The case that went to the Ninth Circuit, and then and the FTC eventually lost in the Ninth Circuit. But LabMD v. FTC is another case, cease and desist order issue there. And we argued that the cease and desist order was unenforceable, and FTC we were involved in that. Louisiana Real Estate Board of the FTC involving a case we were successful in claimed that we had lack of jurisdiction over the Louisiana Real Estate Board,
Right.
where we had an administrative complaint that they had engaged in anti-competitive sort of cartel-like activity. So
Right.
all of these sorts of cases, some of them jointly with justice, and some of these amicus cases, some of them our own cases, we were very directly involved in litigation strategy and planning. The one distinction is, appeals proceed on their own. The commission has to vote to authorize us to issue an amicus brief, and so that can be tricky. But it's the commission's prerogative,
Right.
to do that.
I want to get something out of the AMG case that you just mentioned. I think that's a good. There's a good combined AMG case, which has something to deal with the agency's ability to claw back defendants' ill-gotten gains, and also rulemaking that we talked about. So if we can summarize it as sort of like an aspect where it has something to do with the agency's expansion, or I guess more discipline, or exercising its powers in a more disciplined ways, is that some aspect that as the GC has to always very carefully watch out for, and in instance defend the commission?
Yes. I mean, I think you have to look at every appellate decision, particularly a decision by the Supreme Court, to try and sometimes it gives you, our appellate lawyers, a particular insights on what arguments are working, what ones aren't. Certainly before certain judges, some panels may be more open to others. The Supreme Court's decision, written by Justice Breyer, unfortunately for us, a unanimous decision, did not read into our statute the ability to obtain monetary relief. As I say, even though we cited 19th century and other laws that said the term permanent injunction meant you could get such monetary relief, but the court looked really at how that provision fit into the rest of the commission's structure, and they said, well, you can get recoveries for violations of rules and violations of final orders. That's Section 19. There are other parts of the Act. It's only about 30 years ago, you started finding the ability to get this monetary relief. We just don't think it fits well into the structure of the Act. Congress would have made it clear. So I think that in defending final rules, I think particularly if under Section 6G of the FTC Act, a short statute on rulemaking, I think the GC will have to explain why rules of that sort are substantive rules, not just procedural rules, are consistent with the structure of the Act. You'll have to, and I think maybe even framing the way a rule is written, that may inform that as well. The so-called Magnuson-Moss rulemaking, Section 18 of the FTC Act, Consumer Protection, those are well established. There haven't been many in recent years, but I think based on the specificity of those rules, I don't think that they raise a serious issue. I think Section 6G, the competition rules, raise far more serious issues as to whether an appellate court will find the FTC has substantive authority.
Right.
So a case that's coming up this term that I think could be have very important implications for the FTC is the Axon case. I know I'm not sure, Alden, if you can comment on it because you were there at the time, but maybe just at a high level, what is that case about, and what are the potential implications?
Okay, that case is sort of troubling for FTC veterans because the question is, when there is an administrative proceeding started against a party, in this case, Axon, a complaint has been issued by the commission, during the administrative proceeding, can the party go to federal district court to argue that the administrative proceeding is not constitutionally authorized for separation of powers or reasons or non-delegation of authority. So the idea, doesn't raise directly, is it constitutional? Is the FTC's long-standing admin structure constitutional? But it's, can you interrupt the administrative proceeding and argue to district court it's constitutional? So if the Supreme Court were to say yes, it wouldn't say the FTC's administrative authority is unconstitutional, but it would say, hey, it would hint that the court is worried about it, because it could say, yes, you can go to district court and make this constitutional argument. You responded before the FTC. And of course, that could get if the district court accepted the constitutional argument or didn't, it could get kicked up to a court of appeals, and then eventually, in a few years' time, get kicked up to the Supreme Court. At the same time, just recently, so that calls into question some longstanding assumptions that the FTC could bring these administrative Part 3 trials. And there's recently the Supreme Court, the Fifth Circuit held that the Securities and Exchange Commission could not administer monetary fines in-house through an administrative trial. And that may arguably raise somewhat different issues, because there you actually were at the administration of a fine that might have been penal, that raised questions about the Seventh Amendment. But nevertheless, 2-1, you got a Fifth Circuit panel saying on non-delegation doctrine, on other constitutional grounds, separation of powers, the FTC can't do this. And again, it's another, we don't know what's going to happen. It's going to be re-argued en banc. But there are a number of these cases out there that are starting to raise questions as to whether the Supreme Court, a majority of the Supreme Court, is going to take a dramatic step in assessing the constitutionality of well understood and well accepted administrative tribunals.
Right. Before we go to the more personal segment, I have one area that I think it's very interesting and timely to talk about. Like as the Commission's legal officer, but when you were at the GC's office, so do you see yourself or the GC's office involved in the Commission's interactions with other agencies? DOJ obviously is relevant, but also recently, Chair Cohen and Commissioner Slaughter has filed, I guess, a statement to the International Trade Commission, right, the ITC, on something related to standard essential patents, and so, or in cases like that, would the GC's office get involved?
It's really up to the Commission. Normally, statements of that sort would have been filed by the Office of Policy Planning and would have been authorized by the Commission. And the Commission could decide to authorize statements of that sort. And there was a period in the late 1970s, I believe, when the Commission did have a couple of filings with the ITC, arguing about the scope of Section 337 of the ITC Act, and on fair methods of competition. But generally speaking, there hasn't been this sort of intervention by individual commissioners in recent times. There have been a lot of advocacy filings done generally, again, by the Office of Policy Planning at the state level, to state boards, sometimes even state legislatures. Again, the Commission normally will vote to authorize that, dealing with things like occupational licensing, rules that are pretty clearly or potentially anti-competitive. This ITC issue is something where the Commission had a number of settlements back in the Obama administration, in which patent holders agreed not to exercise their patent rights, like Motorola's sale of its patents to Google. He said if there were patents that read out as standard. We are not going to exercise those rights, have zero licensing rates. There was a Qualcomm case in which I couldn't participate. Was recused, but that involved patent licensing. But clearly you have two commissioners who have a very strong view on that. But of course, they spoke for themselves, and that's always tricky when you don't have a majority of the commission. Now, of course, you have a 5-commissioner majority, but you have two. So I can't say more than that. It certainly represents their points of view, but it certainly the President's executive order 2021 July talked about patents. I think standard essential patents talked about an administration-wide whole of government approach to competition. Now, some might say, and Chair Cohen would probably say, that invites the FTC to be more involved with other agencies. And actually, the Bureau of Competition, and to some extent, had advised, for example, HHS on some competitive implications of health regulations. The FTC had issued reports on healthcare, on patent policy that commented directly or indirectly on things handled by other agencies. But again, those were big reports, policy reports issued by staff. So it may be there'll be more of this. I don't know. Chair Cohen may want to do more of it. She now has a majority, but it certainly is not normal precedent.
All right, and I'll ask one before we go to the next segment. I want to take you back to the time that you were in the policy shop in the Bureau. Do you remember who was the head of OPP at the time?
Well, are you talking? Okay.
Who are the other?
2000 in 2001. Well, Ted Cruz was head of OPP, and then he for about a year and a half at the beginning of the Bush administration.
So I think at the time there were 3 separate policy shops.
There were. Well, yeah, there was the Office of Policy and Coordination in the Bureau of Competition. There was the Office of Policy Planning, which, as I said, has done a lot of reports and advocacy. And I know Ted was interested in writing some briefs. And look, there were people in the office in the Bureau of Consumer Protection who worked on policy. So yeah, I think it seemed confusing, but it's really that they had different roles. I think the OPP was more in general writing reports. The policy shop, when I was there, had 2 roles. One was to advise the bureau director and the chair's office about antitrust policy, but also to help look at cases that were being developed within the various parts of the Bureau of Competition and to offer advice, wanted or unwanted, about ideas about legal theories. And sometimes we sit in on merger reviews. Before a compulsory process, you'd have often BC and BE and policy people sit down, and you'd have the bureau director before recommending compulsory process to the commission. So it was a more, I guess, litigation or antitrust policy focus.
Well, I was just sort of thinking about all the people that came out of the policy shop at that time, because you were there. Ted Cruz was another one. Maureen Olhausen, I think, was there as well.
Maureen Olhausen later became. That's right. I mean, a few years later, she had been on Ted's staff. She had been before in Office of General Counsel, in fact. Then later on, she became deputy and an acting head. And really in 2007 and 8, when Deborah Majoris was chair, she was made head of the office.
Yeah, so that office, that group at the time, it turns out to be a pretty high profile group. Went on to great things.
It was, yeah, and obviously we got new leadership now. We've got a new general counsel, and the one thing they share a similarity. Lots of new appointees. They are Yale Law School graduates.
Well, nobody said the same thing, unfortunately, about the 2001 Anti-Competitive Practices shop, which I was in, unfortunately.
Yeah, but, and there were some of the smartest people in around were there. I remember Rick Dagan,
yeah,
at the time.
No, and then of course you had the rest of us like me. But you had Rick Dagan, you have Jeffrey Green, you have many other great ones.
Oh yeah, right. I used to love arguing about legal antitrust theories with Jeffrey and with Rick too, actually.
And all joking aside, one of the things I really enjoyed about being at the FTC back then was those arguments. OPP would come in, we talked to people about our case. At the time, there was a great interest in doing exemptions cases. So we talked to OPP and Alden, your office, about are we coming up with a good Norr Pennington case? Are we coming up with a good state action case? And that's really, as younger lawyers talk to me about, should I go to the FTC? That's one of the things I really took away, was it was really getting a master's degree in antitrust from really, really smart people.
I think there's no doubt about that. I was in the antitrust division, very smart, capable people, but FTC has more of a tradition of that, the sort of just throwing ideas around. Yes.
All right. Well, let's go to our next segment. Alden, tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, let's see. I spoke French before I spoke English. My mother was French, and I spoke that at home. And I later learned Spanish. She was trilingual, taught for the government. And I've given presentations on antitrust in French and in Spanish overseas.
Have you ever? Do you dream in French or Spanish?
No. Maybe I did at one point, but not now. Or not that I'm aware of.
All right. Well, let's go to our final segment, the Curious Hat.
And now it's time for the Curious Hat.
You know, when we first started the podcast, we used to have a hat. And then we've had the pandemic, and for the last 2 years, we've been online, so there hasn't really been a hat. Nobody has talked about changing the title of this segment, but maybe we should pick that up at one of our meetings somewhere. In any event, the Curious Hat is a series of questions. I will ask you to choose a number between 1 and 10, and I will read you the question that corresponds with that number. If we had a hat, you'd be pulling the question out of the hat. You see how that works? But I'll read the question, and then you can answer it, and we'll see what happens. All right, Alden, choose a number between 1 and 10.
5.
Number 5. Okay. Alden, are you a dog person or a cat person?
Cat.
Why?
My wife insists on it. She loves cats. I'm allergic to them, but we have cats, period.
So, just make sure I understand. So you're allergic to cats, yet you're a cat person.
Yeah, I've gotten used to them. And I'm allergic to dogs also. So I didn't have dogs or cats when I was a kid.
If you could choose an animal that you're not allergic to be that kind of person, what would that animal be?
An animal, I'm not a person. Would
you be a bird person, a hamster person, a fish person?
Bird.
Why is that?
Well, we have, I like seeing the birds. We have a bird feeder outside our backyard, and we get cardinals and robins and sometimes too many woodpeckers making noise in the morning. I enjoy seeing the birds. And
do you ever take punitive actions against the squirrels that are trying to eat at your feeder?
Well, we have a feeder the sometimes put grease and to make it difficult for them to climb, and I think they've gotten the message. I haven't seen too many squirrels lately, so they're on best behavior.
Do you ever feel like the squirrels are outsmarting you?
Oh yeah, it's certainly at times. That's sometimes I think it's actually that we've had raccoons outsmart us, knocking over trash cans and and creating a mess.
Well, Anora, if I were to be a type of animal person, maybe I would be a trash panda person. Let's talk about that on another program. Until then, we'll see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.